This panel is shifting gears somewhat, and the title is Reorganization Takings. I am very briefly introducing people. In your course materials, there is a very robust bio for each person, and it really is quite an august faculty, I think, that John puts together. So our order here is going to be first Kenneth Dinsler. He's Deputy Director of the National Court Section of the Justice Department Civil Division. That's our counterpart within the Justice Department that also handles takings cases. Jerry Stout. Jerry is a worthy opponent of ours in many cases. I can thank John for bringing Jerry here to the conference because it means he's not filing any complaints today, at least, in court against us. Jerry had the pleasure, I think, yesterday of seeing that a case in which we'd filed a rehearing petition in the Federal Circuit that he had won, he now has to answer our rehearing petition. Jerry is at the firm of Greenberg's Traurig, where he handles takings cases among other environmental regulation sorts of matters. Nestor Davidson is a professor at Fordham Law School, and Jennifer Taub is a professor at Vermont Law School.
Good morning. My name is Kenneth Dinsler, and I need to start with the usual disclaimer that everything I say cannot be attributed to my employer, can only be attributed to me, and shouldn't even be attributed to me sometimes. I will be talking about some matters that are currently in litigation, and that means I'm going to have to be circumspect on some of the things I can say when we get to the Q&As. But what I wanted to do is, we're going to be talking about the financial crisis and things that arose from it. But I'd like to take a step back to the previous financial crisis. In the 80s, there was a financial crisis involving financial institutions, primarily thrifts, and it produced legislation in 1989 to try to resolve that crisis, and a series of 122 lawsuits arose from that effort to stem that crisis. Those are called the Winstar cases, which Jerry and I have had the fortune or misfortune to be litigating and have litigated. And 122 started, we are down to one. So it took, this type of litigation can take time. But in this discussion, we're going to be talking about, let's see.
If you just use that, if it'll work.
We're going to be talking about three cases, takings cases that arose from the financial crisis that we experienced in 2008 and 2009. One is regarding Fannie Mae and Freddie Mac. And there's a number of cases a number of plaintiffs that have sued regarding the Freddie Mac and Fannie Mae conservatorship. One of them is Fair Home Funds. The auto dealership cases, which there are three separate plaintiffs, three separate cases being brought under the heading of auto dealership cases, and they've been cited as A&D Auto on the portion that went to the Court of Appeals. And finally, the AIG case, which is technically called Star International v. United States. All are being handled by our office, and Jerry's going to be speaking about Fannie Mae and Freddie Mac, I'm going to be speaking primarily about the AIG case. But before I can talk about that, I have to really take a step back and talk about the auto case. The turbulence in the financial crisis rocked General Motors and Chrysler, and they sought government assistance to avoid bankruptcy and to avoid liquidation specifically. Eventually, assistance was provided to both manufacturers to get them through what is called a prepackaged bankruptcy. And I'm going to avoid talking about bankruptcy both because it's not my specialty and it puts people to sleep. But basically, they knew they were, at the time that they went into bankruptcy, they were being offered and received a certain amount of assistance to help them on the way out of bankruptcy. As part of the bankruptcy, Chrysler and General Motors ended up terminating relationships with a number of their dealerships. with the auto dealers, some of their dealers throughout the country, and that decision to do that was ultimately approved by the bankruptcy court. The terminated dealers sued, and they claimed that the government and they are claiming that the government forced the terminations, and also that the dealers would have thrived absent the terminations. These cases were brought under the Fifth Amendment. Now, the trial court, the government moved to dismiss for a variety of reasons, and the trial court denied those motions to dismiss. But it granted our request regarding interlocutory appeal. And so it went up to the Federal Circuit, and the court focused on a number of issues. But what's relevant today and what we're talking about, one of them was the issue of harm. Generally speaking, if you attended the very excellent intro presentation on taking this morning, you heard about this, but generally speaking, to get a regulatory taking, you have to show harm. You have to show that you were injured, and often to a very, very high extent. Although that can vary among, depending on the case, you have to show a significant amount of harm. Harm in takings cases, you compare the actual world, what really happened, to what is called the but-for world, what would have happened. And this is how the court in the A&D autos and the auto dealership cases discussed it. By necessity, proving economic loss requires a plaintiff to show what use or value its property would have had but for the government action. In the complaints, in the autos cases, what the plaintiffs had alleged, they alleged the actual world, what did happen, and then they alleged, and they claimed that the dealerships were worthless, and they compared it to a but-for world, but the but-for world that they described was one where the government provides all the assistance and the dealerships don't get terminated. So the but-for world was one where they alleged a but-for world that was basically more to their liking, a world where the government still provides all that assistance. And I think one of the plaintiffs' counsel during the appellate argument described it as they wanted more lifeboats, okay? So that they needed more rescuing. So what the court said in A&D Autos is they basically rejected that idea. They explained that the but-for world, first of all, they said the but-for world has to be pled in the complaint. It's a pleading requirement. And they explained, since there can be no regulatory taking without a showing of but-for decline in value, a takings plaintiff must also allege sufficient facts in its complaint to show what use or value its property would have had. Okay, that's the but-for world. And then they go on to talk about what the but-for world can contain. And what they explained was the but-for world has to be one not of a different type of government assistance. It has to be one without government assistance. So your but-for world has to be one where the government steps back, at least in the type of case that they're describing, the government steps back, doesn't do anything, so that you can compare the actual world and one without government assistance. And what they explained was, in this case, the government argues that the plaintiffs have failed to sufficiently plead economic loss, and that in reality, the franchise agreements were worthless absent the government's financial assistance to the automakers. We agree that the plaintiffs' allegations are insufficient. Okay, so the court agreed with that concept, and the court went on to explain, absent an allegation that GM and Chrysler would have avoided bankruptcy but for the government's intervention, and that the franchises would have had value in that scenario. So one way that the plaintiffs could have done what they're talking about, described a but-for world, is if they had said, look, without government assistance, GM and Chrysler would have avoided bankruptcy altogether, that it would have been smooth sailing one way or another. Or a second alternative was, or that such bankruptcies would have preserved some value for the plaintiffs' franchises. The terminations actually had no negative economic impact on the plaintiffs because their franchises would have lost all value regardless of the government action. So what they're saying is the alternative is they would have to describe how in bankruptcy they would have made it through. Their franchises would have retained value. And without those kinds of allegations and ultimately proofs, without those kinds of allegations and proofs, the court should conclude that the franchises would have lost all value regardless of the government action. And so that's where the court set the line, is the but-for world must be one where the property retains value. And that's consistent with the case law, where what the case law says to us is that when you're going to value the property, any property, you do it before and without the government action. So let's say the government wants to build a baseball stadium, and they need 10 parcels. And 3 of the parcels don't want to sell. And so there's condemnation and valuing of those parcels. Those parcels are not valued as the 3 missing pieces necessary to build a baseball stadium. Their value would be up to here, and would give them an enormous windfall, because if there's no baseball stadium, their value is really here. And so what the case law has said is no, you value those parcels, you value property with assuming that the government is before the government's action starts. And so in the autos case, the plaintiff must ultimately show that the franchises would have had value if the government hadn't provided a rescue at all. So the plaintiffs have now altered their pleadings, and the case is moving forward in the trial court. So that's the background that I wanted to start with, so that I can get to the Star International, the AIG case. So AIG was the largest insurance company in the world, but a series of bad investments threatened to bankrupt the company in September of 2008. After the private sector refused to lend, the New York Federal Reserve Bank offered the company a loan of $85 billion. The compensation due back to that ultimately had to be paid on that loan involved 2 types. There was a number of types. Part of it was interest. There had to be interest paid on the loan, but also there was an equity component, and an 80%, or almost 80% equity term that was provided. It was put into a trust, and it gets complicated, but basically a 79.9% equity term was paid as part of the compensation on that loan. And this is basically the deal that was offered that was offered to the private sector. The private sector considered this deal and decided they wouldn't touch it because it was too risky. And so ultimately, the New York Fed steps in and more or less provides that type of a deal to AIG. AIG's board accepted the offer, the deal was done, but that $85 billion was just the beginning. The company teetered on the precipice of bankruptcy for 2 years. It required another $100 billion of government assistance to avoid failure. But eventually, the company was saved, and the government sold its equity interest into the market. Now, after the company was saved, suit was bought by former shareholders. And the company, AIG, chose not to participate, which is why, calling it the AIG case is kind of a misnomer. It is not the AIG case. But the company chose not to participate in the lawsuit. But the shareholders made 2 arguments in the alternative. First, they raised the takings claim, arguing that the government sought too much compensation and that compensation was unrelated to the loan, and thus it was a taking under the Fifth Amendment. Now, a taking can only exist if conduct is authorized. If conduct is unauthorized, then you can't have a taking under the Fifth Amendment. So the plaintiff alternatively argued that the statute authorizing the loan did not allow the government or the New York Fed to seek equity compensation as part of that loan. They claimed that the term then, therefore, would have been illegal when compensation was included as part of, when the equity term was included as part of the loan. They raised this type of claim, they raised under the Due Process Clause of the Fifth Amendment. This is not a takings claim, raised under the Due Process Clause, and it is called, technically it's called an illegal exaction claim. So they raised taking and illegal exaction claims in the alternative. There was a 38-day trial. The court heard testimony from all aspects of the rescue, from 2 Treasury secretaries and the former chairman of the Board of Governors of the Federal Reserve. The court reached the conclusion that the statute did not permit the Federal Reserve to seek equity. Now, obviously, that was contrary to the position we were taking. Because of that conclusion, however, the court did not consider the plaintiff's takings claim. In fact, it specifically says, I don't have to go and consider the takings claims because I've concluded that it was not authorized. But the finding of an illegal term was not the end of the court's analysis. There's no Fifth Amendment violation without a finding of harm. And the AIG court concluded that the plaintiffs failed to demonstrate harm. And it relied in part on the Autos decision and some of the analysis provided in that Autos decision. And it also relied on the Supreme Court decision in Brown, which was also a takings case, again, where the court concluded that without a showing of harm, there cannot be a violation of the Fifth Amendment. And the court concluded that without government assistance, in the Starr case, the court concluded, without government assistance, AIG's stock would have been worthless. And therefore, the government's actions, whatever they were couldn't have harmed the company or the shareholders. And this is what the court said. In the end, the Achilles heel of Starr's case is that if not for the government's intervention, AIG would have filed for bankruptcy. In a bankruptcy proceeding, AIG shareholders most likely would have lost 100% of their stock value. So the court, and this, of course, reflected the AIG's board's minutes. When they voted to take the deal being offered to them, they reached more or less the same conclusion, that without out and rescue, they'd end up in bankruptcy. And they reached the conclusion, and this is echoed repeatedly in the trial court's decision, that, okay, they were giving up 80% of the equity. And they reached the conclusion that 20% of the equity going forward was better than 100% of nothing, which is what they would have been left with. And so what the court said is, the analysis here leads to the conclusion that if the government had done nothing to rescue AIG, the company would have gone bankrupt and the shareholders' equity interest would have been worthless. The case is now on appeal and cross-appeal. So we have, in this fight from the 2008-2009 financial crisis, we have 3 cases that we're looking at right now. These are the 2 opinions that we've seen so far, the Otto's decision and this. But they stand for the proposition that no one was entitled to a rescue. If you want to bring a Fifth Amendment claim, you have to show how you would have been better off without that government rescue. And that if the government stepped back and did nothing, that's how you would have been. That's the position you would have occupied. And so with that, I've got 4, I'm 5 seconds over. Thank you.
Can I get my, how do I get, I do have a PowerPoint.
Okay, go ahead, Michelle.
Oh, you can do it from, there you go.
Great, oh, there it is, great. Okay. I think so.
Sometimes more people to stick to it.
All right, you got it
Yeah.
there.
Yeah. Yeah, great. So let me say, yeah, I want to say first, appreciate the introduction from Billy. And it's true, I am a plaintiff's lawyer, and that probably, at least in this context, makes me a little bit unique in this room. But for the record, I have represented a couple of municipalities in takings claims against the federal government. So municipalities have property rights also. But more generally than that, speaking to a group of lawyers here and being a white Jewish male, it's rare that I'm a token, but I feel like one here, and I'm happy to be here, and it's further evidence of, John's wisdom in putting together a good, well-rounded conference. So I am going to talk about the Fannie Mae and Freddie Mac shareholder litigation, as Ken said. Make sure I know how to work this thing. Do what he did, yeah. Okay.
Maybe that one right there.
Got it, okay. And just at the outset, I want to say this, that I think, and I'm going to try to kind of persuade you that what the government has done here is really quite wrong to the shareholders of Fannie Mae and Freddie Mac. Whether they can make out a takings claim, I don't know. There's a lot of litigation to be done and a lot of shaping of the claims to be done. But if they do succeed, if the shareholders do succeed, and I'm not involved in the litigation at this point, but if the shareholders do succeed, it's probably not going to be in an opinion or for a reason that fits into sort of the way we conventionally think about takings claims as per se rules or otherwise, because the facts are really quite different, I think, than takings claims that we're familiar with. But again, my main point here, and I hope to persuade you, is that I really do think something wrong has happened here, and we'll just have to see what the courts do with it. Fannie and Freddie have long been an important part of the residential housing finance. I mean, their basic business is to buy mortgages, package and sell them on Wall Street as mortgage-backed securities, use the proceeds to provide funding to originators to facilitate the placement of more mortgages. So they're facilitators in the housing finance market, often called GSEs or government-sponsored enterprises. It's really a misnomer. They were originally set up, both of them by an act of Congress, but for decades have been private companies with, for decades before the 2008 financial crisis, have been private companies with public stock and debt and other private company attributes. So when mortgage values plunged in 2008, they faced insolvency, like a lot of other financial institutions involved in housing finance. And the government's bailout transaction for these companies resembled others, resembled AIG in many respects, resembled the transactions that were done with some of the big banks. But it also had some unique features. Number one, and primarily, Congress enacted a special statute, the Housing and Economic Recovery Act of 2008, and first placed the GSEs into receivership, into a federal receivership with a new federal agency, the Federal Housing Finance Agency, as conservator. Then, again, similar to other transactions in structure, Treasury invested ultimately and collectively in both companies, $187.5 billion to shore up their balance sheets and got a preferred stock in return. Treasury did, plus warrants to purchase common stock, which really are not relevant here. They haven't been exercised. But Treasury does hold this substantial amount of so-called Treasury preferred stock. Now, I'm going to skip the slide and then come back. I noticed this morning when I was looking at it. Like other bailout transactions, many of them, all of them really, I think, at this point, it was a huge success. The GSEs have, again, become profitable. In 2012, for example, Fannie Mae earned $13 billion, and in 2013, $84 billion, which included some accounting profits, but nonetheless, real profits to people in the business world. And as of the end of 2013, the companies had paid Treasury back more in dividends than the money that was invested. So how did that happen? The crux of the cases, or at least an important part of the cases, as I said, I've gone different order here, is the so-called Third Amendment to this Treasury preferred stock. In August of 2012, FHFA, as conservator for the companies, and Treasury as the holder of the preferred, amended the terms of the preferred stock. And they replaced the original dividend term, which was a 10% coupon, 10% annual dividend on the $187 billion, with a term providing that I've simplified a little bit, but essentially all future profits of the companies are to be paid to the U.S. Treasury as a dividend. And this has been referred to in the litigation as the net worth sweep. And it also, the consequence of that was also that the Treasury, which had a liquidation preference in the amount of its $187 billion preferred, that liquidation preference will now persist potentially forever because the stock can never be redeemed because all of the money that gets paid to the Treasury is dividends, not redemption of that stock. And the significance of the liquidation preference feature is that there are proposals and a lot of politics involved to do something different with Fannie and Freddie, maybe do away with them, maybe restructure them. In that kind of a transaction, the private preferred shareholders, which we're about to get to, who are the plaintiffs here, would get nothing. And of course, they're getting no dividends going forward because it's all of the profits of the companies are going to the Treasury. So in addition, the FHFA conservatorship remains in place, perhaps forever. So Treasury gets all of the billions of dollars in GSE profits as dividends, perhaps forever. The conservatorship stays in place forever. And shareholders who were in place and owned stock before the conservatorship, before the bailout transaction, before the Third Amendment, get no dividends, no liquidation preference. But they do get legal claims. The plaintiffs are holders of private preferred, several series of private preferred stock and common stock in the companies, the value of which, of course, has plummeted due both to the conservatorship and the Third Amendment. There's district court action seeking to invalidate the Third Amendment under the APA, saying it's arbitrary, capricious, and otherwise illegal action by the federal agencies, so that if the Third Amendment were reversed, the value of the private preferred and common stock presumably would revive because dividends would be available, liquidation preference, and so forth. But what we're interested in here is the takings claims in the Court of Federal Claims, and there are also some breach of contract and illegal exaction claims, but takings claims is the main feature. The leading district court action, just for your information, is called Perry. It's in the district court in Washington. There are some other district court cases pending on APA theories. Judge Lamberth dismissed these claims in September of 2014, and they're on appeal. The leading court of federal claims case, as Ken mentioned, for practical purposes, is the Fairholme case. But there's been no substantive progress there. There's been discovery going on for a couple of years now, almost a couple of years, on jurisdictional issues, and there's a short opinion from Judge Sweeney explaining why she allowed that opinion, which, you know, tea leaf readers can look at and see that maybe what some of the issues she's interested in. But there really has not been any substantive progress. Lots of complex issues, but the crux of it, or at least one crux of it, is that factual allegations include that the Treasury knew in 2012, prior to the Third Amendment, that the GSEs would soon be very profitable, in part because of these accounting adjustments that I mentioned that led to the large 2013 profits, that those would be reversed. So with that background, I want to focus on three sort of substantive issues. There is an active private market, an active market in the private shares. Okay? The plaintiffs here are not well, there are some mom and pops and some former executives that I've also talked to, but for the most part, they're investment firms on Wall Street. And they are trading these shares. And the shares have a positive value. Now, some of the plaintiffs, as I said, purchased their shares. Many did before the conservatorship, some before the conservatorship, some before the Third Amendment. Many of the shares were purchased after the Third Amendment. Those shares are subject to a motion, or the subject of a motion to dismiss, purchase the property after the offending action. I mean, you know, you don't have to have a very good crystal ball to see what's going to happen there. But there are plaintiffs who had their shares before. They bought these shares in good faith before the Third Amendment changed the terms of their stock. So does the active market, the positive market price of the shares, defeat a Lucas taking? Now, before you jump to conclusions, there's a very good argument, I think, in principle, that the Third Amendment destroyed the intrinsic value of the getting rid of the typo, the GSE's private, preferred, and common stock. I mean, there's no dividends, no other rights, no liquidation preference. I mean, these shareholders really have nothing. And yet the stock trades at a positive price. Why? Well, case law suggests that the reason for the positive price matters. In a couple of cases some time ago, the Federal Circuit in Florida Rock explained that the Court of Federal Claims in that case, there was a positive, this was a wetlands permit denial case. The Court of Federal Claims held that it was a taking, but there was a positive price to the land in Florida after the permit denials. The Court of Federal Claims discounted it, said that these were uninformed buyers, that anybody fully informed about the consequences of the permit denial and the regulatory scheme would pay nothing. Federal Circuit said you cannot disregard an entire market. There's a positive price there, and that has to be accounted for. But more recently, in a case called Lost Tree Village Corp., which is still pending to some degree, and in which I'm involved and some other people in the room are involved, the court suggested that it may not matter if the value of the property after the deprivation is due solely to speculation that you could win a takings claim. Okay? Otherwise, the circularity there would eviscerate Lucas. I mean, if these Wall Street investors are buying these GSE preferred shares now solely because they think the plaintiffs are going to win the case, then that may not defeat a claim that the Third Amendment destroyed the intrinsic value of those shares. So we'll have to see how that comes out, but that is a question that I'll leave. Another question that I think these cases raise is what kind of property rights are there in corporate stock? You know, the government has argued that there's no right to dividends, right? Corporate law, they're discretionary. The board of directors can declare them or not. And the government has also argued that the impact on the liquidation preference that goes with the preferred is not ripe yet. But the private preferred and common are trading at a positive value. So the investors are paying for something. Again, are they paying for the right to win the lawsuit? Are they paying for something else? I mean, stock, I think, intuitively, share of stock, you know, I own some stock, and I think it's property, but Are there any rights there that really can be enforced in a takings case? And I note here that the plaintiffs also claim kind of a physical taking theory where they say the Treasury appropriated the dividends for itself. The dividends that would have gone to the private shares are now going to the Treasury. Okay. Lastly, just as a question to pose, again, there has been no real no substantive progress in the takings litigation arising from the Fannie and Freddie Third Amendment and whole situation. Is the government conservatorship for a now highly profitable company? I mean, is that in itself a taking, or does that raise takings issues? HERA, the statute, provides that the conservatorship can be converted to a receivership if that became necessary to liquidate the companies, but the statute provides no other way out of the conservatorship. Presumably, FHFA has discretion to disappoint itself or unappoint itself. I don't know about that, but there's nothing in the statute that provides for an end to the conservatorship. The statute does provide conditions for the appointment of a conservator, and you can imagine what they are: assets insufficient for obligations, unsafe and unsound condition, and so forth. Those conditions presumably were met when the conservator was appointed, but they're no longer. It's no longer the case that the companies now are very, very profitable. They're making billions of dollars literally each quarter, and so. Brought to my mind the Youngstown Steel case, which I'm sure we all recall from law school, where President Truman took over the steel mills in the 1950s, and the Supreme Court said, you can't do that, President, because Congress has not given you statutory authority. It was a separation of powers case. The President had no authority to take over the private steel industry. And so I pose the question here of, has the statutory authority for the conservatorship dissipated or disappeared now that they are so profitable? Or, alternatively, is the federal government going to run these companies forever through the FHFA as conservator, take all of their future profits as dividends, and tell the shareholders who purchased their shares prior to the Third Amendment? Okay, let's put aside the hedge funds that you may read about in the newspapers that bought their shares after the Third Amendment and they're clearly speculating on the outcome of the litigation. Put those people aside. What about the hedge funds that looked at Fannie and Freddie and said, we think these companies can turn around and be profitable again? They bought their stock, and then the government comes along with the Third Amendment, takes all future profits forever, and keeps the companies in conservatorship forever, and guess what? All the money's going into the federal treasury. I think that's wrong. Whether it's a taking depends on some of these issues and probably lots of others that will be litigated in these cases, I'm confident, before they're done.
Thanks. I don't actually have a PowerPoint, but I'm happy to leave Jerry's up there because all I have are questions and I don't have any answers. First of all, I want to thank you, John, for putting together an incredible conference. Doing it once is impressive. Doing it 18 times really is a little intimidating. So John asked me to offer some thoughts in general about the intersection of takings and economic crisis to tie together the range of cases we've been seeing coming out of the housing and economic crisis of 2008, 2009. And I want to take this up to a slightly more abstract level than the wonderful detail we've heard about the specific cases, and suggest that there are two, to me, particularly interesting overarching aspects to these cases, and I'm going to focus on one of the two. The first is just to pivot off of our first panel. I think it is very interesting that we are engaging as people interested in the takings clause, as people interested in property, in a new realm of property. It's always been out there. There have always been cases that involve the intersection of entity ownership, of shares and other corporate rights with the takings clause, but obviously this is becoming much more prominent today, and for those of us whose bread and butter is in writing about these things, thank you all for litigating it for us. But second, and this is what I am going to focus on, is if we map that general intersection between corporate ownership, between the bundle of rights that one might have in a corporation. And some of the cases actually involve claims in a derivative way about property that the corporation itself has, but I'm going to set that to the side. How does that change, or how might that change in times of crisis? And the lens I want to offer here is actually one that looks forward, not back. I want to think about what you might call the fire next time. One thing we know with pretty much certainty, going back to questions and no answers, is that there will be another economic crisis, right? If you go back through history, 1785, 1792, 1796, 1819, 1837, 1857, 1873 to 1896, 1901, 1907, 1920, 1921, a little downturn in 1929, the 70s, the savings and loan crisis, and then the last decade, the housing crisis. You see a fairly regular cyclical pattern with perhaps some attenuation now that we have a more vigorous regulatory state after World War II. But the pattern hasn't changed, and perhaps the highs and lows have gotten longer and higher and lower. But there will be a crisis next time. And what I'm really interested in is what, in takings terms, the litigation that we're experiencing now might suggest, both for the latitude that public officials will have to respond to the next crisis, and also what investors, as they think about investing, at least in potentially systematically important companies, which is an idea that has emerged from the most recent crisis that didn't really exist before the last downturn. What should investors think about, at least in terms of takings liability? And I think the short message, spoiler alert, the short message to future officials facing the next financial panic is be not afraid. I think the message to investors is perhaps some version of caveat emptor. If you concentrate your investments in systematically important institutions, financial or otherwise, Chrysler and GM are other examples of institutions that can become extremely important to the macro economy that aren't necessarily banks or financial institutions. In addition to the ordinary background risk of bankruptcy, or if you own shares in a bank, resolution authority. We can talk in the Q&A a little bit about what Title II of Dodd-Frank might now do to some larger category of companies. You have to now take into account the possibility that if the company you've invested in is systematically important, does face failure, and the government intervenes to prevent that harm to the larger economy, you may end up losing some or all of the value, and you may not be compensated, at least under the takings clause. So why is that? How do we get that from the traditional jurisprudence, and might we be facing an interesting irony that the fact that these cases are being litigated now and largely the government is prevailing on various theories, it might reset the baseline within that jurisprudence. I'll just say one word. The last time I was invited to the conference, I talked about the idea of emergency. There's a very well-established exception to takings liability. In the context of emergency, the typical case, of course, is a wildfire, and the government comes in and creates a fire break, and the person whose home is destroyed to create the fire break can't then complain and seek compensation for the, if it's reasonable, actions of an official in that moment. And I argued in a paper that I talked about last time that this actually applies, at least logically, very similarly in times of economic crisis. Similarly, there's a long-established tradition that one thing that another exception with the takings clause, of course, is property that is used to harm other property. That certainly, notwithstanding Lucas's attempt to destroy or Scalia's attempt in Lucas to destroy the harm principle, that still is a foundational principle in property law. And that too can, I think, logically apply in the context of certain forms of corporate ownership that have fairly clear negative externalities. As far as I can tell, no court has really taken any uptake on that theory. Not surprisingly, perhaps it's a little bit out there, but the closest we've come is some loose language in Judge Wheeler's opinion in the AIG case, where he had the kind of chutzpah to cite Blaisdell for the idea that emergency doesn't exactly expand power, and those who know the Blaisdell case can join me in looking at the irony there. So we'll set aside emergency, we'll set aside the kind of Mugler, Hadacek Miller v. Schoen line of cases, and let's just talk about much more plain vanilla traditional takings doctrine. And here I think the case law that has emerged so far points to really two complementary theories under which we may be resetting the baseline. So in Penn Central terms, but also in Lucas terms, if where we end up is a per se rule, and I think you can get there in either way. One question is the intersection of economic crisis and corporate ownership is what we now must think of as reasonable investment-backed expectations in light of the current crisis. In Lucas terms, we can get at the same set of questions through what inheres in title, and I'll talk a little bit about some of the complications there. So those are two very closely related ways in which the expectations or the actual bundle of ownership rights that someone investing in a private entity today should take into account thinking about, again, the next crisis. The other way you can get at it is through the question in Penn Central terms of economic impact, or if we're in a Lucas world, the question that Ken alluded to or talked about of whether there has been harm. So even if obviously you have a Lucas claim in this context, you still have to show that there has been harm, and at least in the handful of cases that have been litigated so far, that there's a pretty significant barrier there. Okay, so let me unpack that a little bit with the 6 minutes I have remaining. And I'll just say as well, and we can talk about this in the Q&A, I think there's some very, very interesting questions about the intersection of corporate law and government ownership that may implicate takings, but also provide other constraints. And there's now a bit of a literature that has been developed on there. We're going to not really talk about that here. So let's just look at the kind of two main avenues in which the current response to the most recent crisis may be changing how we should think about the crisis next time. The first is how we are reshaping the reasonableness of expectations in that prong of the Penn Central analysis. And I think one way to think about the reasonableness of expectations is, as with Fourth Amendment privacy, as a kind of objective, subjective test, right? What does this particular owner expect, but is that reasonable in light of the regulatory environment, reasonable in light of background principles? And if you think about how the crisis played out, the actions the government took in the companies that it did, and how the litigation has shaken out, at least so far, I think there's an argument you could make that for a category of companies going forward, the investment-backed expectations have to be evaluated. The reasonableness of the investment-backed expectations has to be evaluated very much in terms of this now sort of the sequence of events we've now seen. And that's interesting in terms of how we might shape corporate property more generally, right? So we've talked about land has certain social expectations, intellectual property has its own valence, as Carol Rose has written a lot about. Water has its own set of trade-offs, personal property. Money used to be clear, now post-Kuntz, who knows how the court's going to treat monetary claims. But corporate ownership really has its own very interesting internal logic. In many contexts, it's highly regulated. Again, occasionally you'll see cases that challenge resolution authority in the FDIC and similar contexts, and those tend to fail. So even though this, like most property, is defined by state law, here, Delaware or New York corporate law or other corporate law, it is deeply embedded in a regulatory scheme that is essentially federal in nature, and at least for a category of companies that are, as the saying goes, too big to fail. That federal regulatory scheme has to be taken into account when anyone invests going forward. And I think, again, you can get to essentially the same place through the Lucas lens of what inheres in title. Someone's going to, I assume, raise their hand and ask the question that came up in Palazzolo and has come up in other cases about the extent to which a newly enacted regulatory regime can inhere in title. I think that's a relatively interesting question in the context of land. I don't think it's that interesting in the context of corporate shares, where companies are subject to a constant shifting arena of regulatory restrictions, and someone, especially a sophisticated buyer, purchasing stock going forward really has to be on notice that those regulatory shifts now in view. And we can talk about whether one can lose that claim over time. Part of the issue in Palazzolo, of course, was that someone might have purchased the right to challenge a prior restriction. Just very briefly, you can get at a similar reset of expectations through the idea that in the cases that at least have come out of the current crisis, and I think if there's a pattern here, it is that the companies involved were all on the brink of failure when the government intervened, and we can talk in the abstract about whether the government ever does or would intervene with a healthy company. It certainly doesn't seem to happen very often. And so it raises a question, when I read Judge Wheeler's opinion, which I think could have been 2 pages long, it could have just said 20% is more than nothing. But when I read it, it did remind me of my first year crim law class, and I don't actually remember what the answer was in crim law, but are you liable if you shoot someone who's jumped out off the top of a tall building, right? I don't know that that should excuse any and all government action, but certainly does seem to put a different spin on the equities involved. So all to say, now that I'm running out of time, as we think about the inevitable next crisis, I think one lesson we can learn about the intersection of corporate ownership and all of its interesting nuances in corporate law, and at least the takings clause, forget the APA, forget a lot of other interesting questions, at least the takings clause, is that a reasonable investor should be on notice now that if they take that risk and it comes to bear, the takings clause should not be a barrier to governmental action.
So the title of my talk, I don't have slides, but I'll tell you, it's Saving Homes Without Taking Property. And this is also financial crisis related. But I do want to warn you, you heard from my fellow panelists that bankruptcy puts people to sleep. And I know that he said we might not always quote him. But contrary to that assertion, I hope to convince you that bankruptcy can be riveting, especially when it's used to help people save their homes. So what I'm going to focus on is the question of whether the U.S. Bankruptcy Code can be redesigned to better protect struggling homeowners during an economic downturn. And I agree that another one is inevitable, and even if it isn't tied to mortgages itself, as we've seen over the course of financial crises, home prices typically drop during these instances. So in particular, I'm looking at the question of whether the Chapter 13 can be amended to allow homeowners who are underwater, meaning, as you know, they owe more on their mortgage loan than the home is now worth, whether the amount they owe can be reduced to the value of the collateral. So, for example, if they owe $300,000 and the home is now only worth $200,000, whether they can go through a bankruptcy plan under Chapter 13, restructure the payments, and only owe a principal balance of the $200,000. And I'm asking this question in the context of a takings conference because I work with John, and I spent several years working on a book on the financial crisis, which I probably have to plug now because it's out in paperback. It's called Other People's Houses: How Decades of Bailouts, Captive Regulators, and Toxic Bankers Made Home Mortgages a Thrilling Business. And I worked on this, and one central question is why this very type of amendment didn't pass. It passed in the House and failed in the Senate. And I looked at that and other issues, including the policy issues around that in this book. But the one thing I absolutely avoided was the takings question. And so I want to focus on that now, and this is the beginning of my inquiry. Because as we know, the Constitution, Fifth Amendment, does say nor shall private property be taken for public use without just compensation. And so what I want to focus on is whether if the change were made to the bankruptcy code and applied retrospectively, not just prospectively, do we have a takings issue? I'm going to decide that the answer to that is no, that there's not a problem. But I think it's important before I get into the legal nitty-gritty, before my time runs out, to tell you why I'm asking this question. I'm asking this because maybe we can go back. We've already been going back to September of 2008. And you might remember from the time the Bush bailouts began up into 2009 when President Obama took office, and we had additional money going to the banks. We had the auto bailouts. We had the AIG bonuses. Some of this may remember. The public became increasingly enraged. We come to the spring of 2009, and unemployment hits 10%. And people were not very happy. And so part of what folks in the administration did was to go around and talk to the public to justify the bailout. And I often return to something that Ben Bernanke, who was then Fed chairman, said. And it was a large town hall. And I think this encapsulates, and I think it's true, right, but encapsulates the justification for the bailouts. And he said, quote, "It wasn't to help the big firms that we intervened. These companies have turned out too big to allow to collapse because when the elephant falls down, all the grass gets crushed as well." And then he said, "We really need a new regulatory framework that will make sure that we do not have this problem in the future." Now, we can, and in other places I've talked about whether Dodd-Frank as currently implemented provides that regulatory framework to deal with the elephants. But I have not yet fully focused on what we've done about the grass. And 7 years after the crisis, I look around and the data is in dispute, data are indisputable, but the elephants are larger than before, and the grass is still crushed. In terms of, I'll try to get through this part briefly because I'm going to focus on homeowners, but the top 6 banks, U.S. Bank holding companies, are larger than they were before the crisis. They have about $10 trillion in assets now compared to $7 trillion before. When we looked at the living wills from last summer, they haven't been analyzed this year. Tom Honig, who is now vice chair of the FDIC, said that none of them could file for bankruptcy without precipitating a financial crisis. And the Title II resolution regime that Nestor was referring to, it's not entirely clear that they could go through that regime smoothly, but even if they did, just so you know, that gets funded with a line of credit from Treasury and paid back later by the bank, so that we're now, if the unpreferred route of Title II, as opposed to a bankruptcy for these failing firms, would to occur, it sure looks like another taxpayer-funded bailout. But that aside, let's go to Main Street, because that's where I want to talk about things. More than 5 million homes have been lost to foreclosure since 2006. Although fewer homes are underwater on their mortgages, there are still, according to Realty Track, 7 million residential properties that are considered seriously underwater. And by seriously underwater, that means they owe at least 25% more than the market value. Being underwater on your mortgage doesn't necessarily mean you are going to default on payments, but obviously it makes it difficult to move for new job prospects. It means you've got to come to closing with a check at retirement. It also holds back the economic recovery because people spending more money on to pay for an asset that's not worth as much means they can't spend as much in the economy. And I could continue on this. So we know also that future crises are inevitable. So now I'm complaining about a problem. What's the solution? So one of the ways to deal with this is to amend the bankruptcy code. And to be able to use Chapter 13, as I've mentioned, to pejoratively, they say, to cram down the amount of principal that you owe on your mortgage to the value of the collateral. So this would be designed to do what bankruptcy is supposed to do, which is to let borrowers emerge with a fresh start, able to pay their bills and hopefully keep their homes. This used to be done prior to 1993, but after Nobleman versus American Savings Bank, courts can no longer do this. So some language in this part of the statute 1322b2 that basically treats a home, a loan secured by a primary residence, so a first lien on a principal residence, differently than other collateral. So if I were going into bankruptcy going through not a liquidation, but a Chapter 13 plan, I could hold on to nearly every other type of asset. And if I owed my lender more than that asset was worth, I could still keep that collateral, and the amount I owed would be crammed down. But if it's my principal residence, that's not the case. So there's this anomaly that I think should be fixed. So what are the details of this proposal before I talk about the possible takings implications? The lien itself will remain in effect. I'm not talking about canceling the lien. If after the plan, the homeowner failed to make the payments, there still could be a foreclosure. The principal balance would be reduced, and of course these interest payments and the amortization structure might change. So is there a takings problem? Okay, so this gets a little bit complicated. I'm going to bifurcate the conversation between prospectively applying this. So if this change is enacted with regard to mortgages going forward versus if this change is enacted and applied to pre-existing mortgages. So it's interesting, prospectively, there are some arguments made by folks, including Charles Tabb, that actually the takings clause does not at all affect secured creditors' rights on a prospective basis. He has an interesting piece out right now about this, and his argument is because of the bankruptcy clause, which is in Article 1, Section 8 of the Constitution. It says the Congress shall have the power to establish uniform laws on the subject of bankruptcies through the United States. He and some others would argue, prospectively, you can kind of do whatever you want. I don't even need to take that position. I won't need to argue that with what I've described, there is not a takings problem prospectively or even retrospectively. Just there are others, of course, who disagree with that position. Okay, so what's the analysis either going forward or back? I think you now have to separate the lien itself, which is the right that gives the right to foreclose on the home, with the contractual rights, in the promissory note, because there's two different things that obligations that are entered. So in terms of the lien, you can go back to Wright versus Union Central, Supreme Court case in 1940, and then more recently, U.S. versus Security Industrial Bank in 1982. And what those cases in sum say is that the constitutional rights of the secured creditor to obtain repayment of the debt is different and separate from the property right in the collateral. With regard to the property right in the collateral, the lien, the constitutional protection, I believe the cases say, is just up to the value of the collateral. So this idea of cramming it down would be fine. As for the contractual rights, to the extent that you want to separate those, and not sort of say they're part of the lien entirely, I think if you go through a general analysis under what is the economic impact, what are the reasonable investment-backed expectations and the sort of the character of this alleged regulatory taking, where do we get? So just to be clear, what are the mortgage holders going to argue, right? They're going to argue a number of things, including that when these loans were extended, or when the mortgage was purchased into a pool, depending on who owns the loan, that the expectation was that homeowners would not be able to do this in bankruptcy. But keep in mind, homeowners can go into Chapter 7, and in a Chapter 7 scenario, although they don't keep the home, basically at that point, the value of the home is what the liquidation value of the collateral is. And under this proposal, the way the court would be able to restructure the promissory note would be you would owe that $200,000 I'm talking about, and then if the mortgage is out over 30 years, whatever the interest rate established would be, the stream of payments would have to be the equivalent to the present value of the collateral. So the idea would be that you would not be deprived of your rights, the constitutional right to get up to the value of the collateral, even if you're being paid out over time. But I think there's an argument that the difference would be, at least probably retrospectively, that one of the rights that the lien holder has, that they might cherish, is actually that coercive value of being able to get someone to pay because they believe that they're going to be kicked out of their home. I haven't seen that coercive value recognized in the case law, but I certainly heard those arguments being made that homeowners might try to use this to their advantage and go into bankruptcy court even when they can't afford to pay, and to use bankruptcy strategically. But there's no law against using bankruptcy strategically. It's done by in commercial bankruptcies as well. So I do think that as long as I do think this could be applied retrospectively. There's some nuances here going back to this, a case predating Wright, which is Radford. Without getting into too many details, it's not as solid of a case applying retrospectively. So the conclusion then you would go to is say, okay, well, what would the just compensation be? And if the just compensation here is the same thing, which is the value of the collateral, I think we end up economically in the same place. But even if we don't, in the worst case scenario, let's assume for a second that it would be a takings and that the government does not want to pony up the money to buy all these mortgages. Okay, if that's the worst case scenario, that militates in favor of the argument that we should amend the code now and not wait until the next crisis to apply to retrospectively. The problem, of course, what you get to are the existing mortgages that are still underwater, but nevertheless, I think this is a very strong argument, even if it's not that murky, even if I believe that it can be applied retrospectively, to amend the code now to make sure that the expectations are set going forward that Chapter 13 could be used to do this. And then when we have an economic downturn, it's not just the folks who are too big to fail to get bailed out, but also the folks who always end up being too small to save. Thank you.
All right, that's great. Yeah, I wanted to actually open it up first to the panel.
You know, I'm often proven wrong, but rarely so quickly. So henceforth, when I discuss bankruptcy, I will say that when I talk about bankruptcy, it puts people to sleep.
But among you, do you have any questions for each other? All right, well, let's go out here. Go ahead.
Thank you for this tremendous panel. I'm Tim Mulvaney from Texas A&M, and I'm inclined to agree. I thought Nestor made a very persuasive case that these cases that we've been talking about on this panel could certainly reset the baseline. I was curious if Ken and Jerry thought that the baseline might be reset in the exaction takings context. I know the AIG case is kind of ironic that it's called an illegal exaction case because it's not exactly, we're not talking about exaction takings per se, but it strikes me that AIG could really hit at the heart of the Nolan and Dolan preservation of the substantially advanced Egan's test, because I see AIG as saying there's a condition to this loan here that does not substantially advance a legitimate governmental interest. You can't take an equity stock in a rescued company. And that cannot give rise to takings liability. And if that's the case, then it really is completely undercutting Nolan and Dolan. And if that is true, then perhaps, and this is being a cynic, but maybe the government might reconsider whether it's worth appealing this case at all.
Can I jump in with one quick thing, even though it wasn't addressed to me, which I think that I would say that if 13.3 were amended, I don't think that would be, first of all, it wasn't a takings issue, it was the exaction question, which you mentioned, but I think if 13.3 were amended to give the Fed the authority to do that, then I don't think it would be, I don't think it even reach these constitutional questions, right?
Wait, Jerry, did you want to respond?
Well, I'll be happy to try to bail
Go ahead.
my good friend Ken out from not having to respond.
But
I'm
super.
Sure
So he's going to get a
I'm not
chance
sure I
to.
have a useful response, so I'll
Go ahead, Ken.
So there's a finite amount I can say. And what I'm going to say, I'm going to take away from the AIG case and just speak in generalities. What I would say is that so if hypothetically, and what we believe, if this was legal, so that takes it away from the illegal exaction. But if there's then there is what was raised is a Nolan Dolan issue, and it just seems separate from all of these cases. Nolan Dolan themselves seem desperately tied to land use, and that the idea that to transport them anywhere out of land use. I mean, land use, you start thinking about it, and you start thinking about this idea that, okay, you know, if you give up your house, you know, we'll let you build that porch on your house, but only if you'll get, you know, let the public have a right of way to pass through your property. And by the way, we'd like your chandelier. I mean, at some point, you know, for a piece of land, you can understand sort of, but they can go too far. And at the same time, you've got to give some flexibility to the local regulators so that you want to add that porch, that's fine, but maybe it's a fire hazard if you extend it too far, or maybe you can't make it out of this material. So it makes perfect sense in land use. Once you get away from land use, you start to talk about just how people are going to use personal property, and like it doesn't really seem to hold. And so the transportation of that to any other realm, including a realm such as financial institutions and the like, seems to be of a completely different kind. And so the short answer is Nolan Dolan probably should stay where it is set right now, which is land use and the porch and the path and the second floor on your house, where it fits in with what we're thinking about when we think of takings.
Nestor, go ahead.
Well, I do think, you know, in a sort of post-Kuntz world, there is an interesting question about whether we might see an expansion of a broader notion of unconstitutional conditions, which starts to get a little bit decoupled from a kind of some of the land use issues, I think, in which it originally arose, and whether there's a more vigorous version of unconstitutional conditions in the property context than we might see in other areas, because you can have all sorts of constitutional rights implicated in an unconstitutional conditions case. And once we reframe the Nolan Dolan line of cases away from a kind of takings paradigm and towards an unconstitutional conditions paradigm, then I think then you get into some tricky questions when you get to setting aside the 13.3, setting aside the question of authority, which I also think will be fixed next time. It wasn't an issue in TARP. It wasn't an issue with HERA. I mean, you know, it's not very hard to write the paragraph at 2 in the morning when they're going to write the next bailout, right? We have a pretty, I'm sure someone in the government has written the memo that says, here's how you fix the authority issue, right? That's pretty easy after the crisis. And if they haven't, I hope they will. But I do think the unconstitutional conditions question is an interesting one, and I don't think we have really much guidance. It's clear the court is not interested in letting it live purely in the land use area, and I think there are a whole set of questions coming. I'm sure we'll talk about it later in the day, but you know, legislative, you know, all the stuff coming out of California and the, you know, who would have thought that inclusionary zoning would be threatened in this way? I mean, we don't know where we're going with that, but that's certainly not limited to you know, bailouts and corporate takings.
Go ahead, Jerry.
You know, let me just say this. I mean, that's all very interesting, but I don't understand how this addresses...
You can stop now, Jerry.
I'm more with you than Ken on this, but I don't see how this addresses the financial, you know, the economic consequence, sort of heart of the decisions. That if let's say it's an unconstitutional condition, or, you know, there's an argument about that, you know, the fact of the matter is, I think that without the government's assistance, the plaintiffs would have nothing. And so that it sort of becomes academic about whether it's an unconstitutional condition in the context of these cases. You know, if that's true, as a matter of fact. So,
Alex.
So my question is prompted by Nestor's comments about reasonable investment-backed expectations in the corporate context. Because as you say, the regulations are constantly changing, value is changing minute to minute, so that's very different than in the real estate context. And I wonder if is it possible to draw on some of the cases from decades ago about no absolute right, there's no rights to a favorable business climate, to profits, and does this intersect at all? I think it does intersect with some of the current takings claims that are being raised by the coal industry with regard to the EPA's Clean Power Plan. I mean, these are essentially similar types of claims, and I wonder if you've thought about the intersection of those.
Yeah, it's a great question, Alex. I think that at least as they're parsing out in these cases, and actually it comes up in the auto dealer cases pretty clearly, the courts, I think, are going to end up drawing a line between kind of indirect interference and direct interference. So if you pass a regulation that says that, here's the air quality standard for cars, and some number of dealers end up going out of business because all they can sell is old clunkers, then that's just, you have no claim against the government. That's just, you're a consequence of a changing regulatory scheme. But if the government does something that targets a specific owner, then that might put us in a different realm. And I'm not sure I agree with the theory in the Chrysler and GM cases that the dealers are on the wrong side of that line or the right side of that line, depending on which side you're litigating. But I think that's the line that we're seeing emerge. And if that's the case, then I think, if you happen to be on the wrong side of being a coal-fired power plant generator and we've passed general regulations, we haven't targeted you necessarily specifically as an individual owner as opposed to someone subject to a broad regulatory scheme. Same debate plays out in Lucas. I mean, I don't know that the court got it right that David Lucas was singled out in the way that Justice Scalia thought he was. I thought the dissent had the better of the argument about the breadth of the regulatory regime at issue. But I think that's the same line.
John, go ahead.
I want to hear Jerry's response to Esther's argument that the expectations can be factored into the analysis, and it really doesn't make much difference whether they would be brought into the analysis under Penn Central or through in a Lucas type case. And I'm guessing that you might take a different view about how a Lucas case would play out.
Okay, I'm not sure I understand the question, because I think I agree with a lot of what, should I stop there?
Yes.
That
answers the question.
The experience with these cases, investors have to be mindful that there'll be another crisis and that the government has enormous power. So
do you think the risk that in the time of financial crisis, the government may need to intervene and take over a corporation is a risk that adheres in title that would represent a defense to a Lucas-type claim? You don't think that, Jerry. Come on, you got to represent that point of view, the opposite.
I think that it's too broad a question, and that's why I think that there are so many more questions in the Fannie-Freddie litigation than where that, the topic that Ken addressed really doesn't come up, or it's certainly not at all as central in the Fannie-Freddie cases, because the offending government action, if that's the right word, the deprivation there arose primarily, in my mind, from the Third Amendment and not from the initial $187 billion investment. And so you have, and really what you need, is a takeover a taking? It's just too broad a question. I mean, I think, what I'm focused on in those cases anyway is the people on Wall Street who, after the takeover, government's a conservator, and they're looking and they're saying, these companies are going to survive and they're going to prosper and they're going to be profitable again. I'm going to go buy some of their stock at 10 cents on a dollar. Okay? After the government's already come in, they buy the stock and they're right. The companies do prosper. They're enormously profitable. And then along comes the Third Amendment and wipes them out. So, that's, facts, the details sort of matter. And so, should anyone who invests in General Motors or Wells Fargo Bank think that they could be wiped out by a government takeover in the next financial crisis? And would that be a Lucas taking? I don't know.
All right. We're gonna have to move on to our next panel. We're at time here. This is terrific.